A new ruling by a U.S. appeals court has affirmed the cancellation of a borrower's $200,000 in private student loans. In McDaniel v. Navient, the U.S. Court of Appeals for the 10th Circuit affirmed a lower bankruptcy court's determination that a borrower's private student loan debt could be discharged in bankruptcy. The Bankruptcy Code treats student loan debt differently from most other forms of consumer debt, such as credit cards and medical bills. Borrowers must generally prove that they have an undue hardship in order to discharge their student loan debt in bankruptcy. These restrictions initially only applied to federal student loans, but were subsequently expanded to cover private student loans following the passage of a 2005 bankruptcy reform bill. The undue hardship standard applied to student loan debt is not adequately defined in statute, so bankruptcy judges have established various tests which vary by jurisdiction to determine discharge eligibility. In order to show that they meet this standard, borrowers must initiate an adversary proceeding, which is essentially a lawsuit within the bankruptcy case that is brought against the borrower's student loan lenders. Through the adversary proceeding, the borrower must present evidence showing that they meet the undue hardship standard, while the student lenders present opposing evidence. The adversary proceeding can be a long and invasive process for borrowers, and can get quite expensive for those who retain a private attorney. Student loan lenders may also have significantly more resources than borrowers, which can give them an edge in the litigation. As a result, many student loan borrowers are unsuccessful in proving undue hardship, and many others don't even try. The recent ruling from the 10th Circuit could change this. The borrower in the case had taken out $120,000 in private student loans. When she became unable to afford the monthly payments, she said that Navient would not work with her to provide an affordable repayment schedule. Private student loans are not eligible for federal income-driven repayment plans. She eventually went into bankruptcy. After her bankruptcy ended, Navient added on tens of thousands of dollars in additional interest, leaving her in an even worse position and causing her to pay even more money to Navient. She ultimately then petitioned the bankruptcy court to reopen the bankruptcy case to rule that the private student loans were, or should have been, discharged. Rather than basing the decision on the undue hardship standard, the bankruptcy court found that the private student loans at issue did not even fall within the undue hardship provision of the Bankruptcy Code in the first place.